with us. This is Planet Green Trees, episode 156. And without further ado, we're going to go right to our guest, esteemed lawyer, really smart guy. I got to say that I've talked to a lot of lawyers about medical marijuana, and this guy knows what he's talking about. Welcome, if you will, to the Planet Green Trees returning guest, Attorney Daniel Groh. Welcome, Dan.
Hey, Michael. How are you? Thanks for having me on the show.
My pleasure. Thanks for taking the time. I know it's busy and a lot of tragedy out there. A lot of people with sad stories and cases, and a lot of beatdown from the courts. Tell our listeners, everyone's very interested. I want to ask you a couple questions about Section 4 in general, but give the court a little backdrop. I mean, the listeners.
Yeah, of course.
Of the case.
Well, Michael, the short answer here is that in cases like Cynthia Jones's case, the judge should have just dismissed the case. We shouldn't even have this case on appeal. She was compliant with the amount that she was allowed. She had her cards with her. That should be the end of the story. That's what we argued. And the judge, though, is like, well, no, I want to hear about the true purpose of why she had this marijuana. Oh, and maybe she's not a Michigan resident. And, you know, the evidence...
Who's the judge, may I ask? Who's the judge?
This was Judge Pasula in Berrien County. So by creating these false issues of fact, questions of fact, she was able to deny my client protection under Section 4. She should have had her case dismissed early on in the case. Said, yep, you comply with the numerical limitations of the Act. The case is dismissed. The prosecutor didn't like that. The judge didn't like that. So they came up with this idea that if there's a question of fact, I can't decide it. There were no real questions of fact. The judge didn't want to rule the way that she should have ruled. That's my personal opinion, and that's something that we're going to have to flesh out on remand.
I like that. I like the way that's on. For those who didn't pick that means that there's going to be additional appeal. We're going to get a good ruling, and it's going to be sent back. And when it goes back, you're saying as you go back now, right?
Well, there's two ways you can go in a case like this. You could either accept the remand and go back to trial court and make the judge do it right, or you could say, well, this Court of Appeals opinion has some problems, and we think the Michigan Supreme Court should look at it. One of the major problems with the way it's drafted is it really doesn't give the lower court much guidance as to who gets the benefit of a doubt on a close call, who has the burden of proof, what's the true protection of the presumption stated in subpart 4D of the Act. And what I told the Court of Appeals is that unless the grounds for immunity are blatantly contradicted by the record so that no reasonable jury could believe it, such that the court couldn't adopt that version of facts, that, it would have to be dismissed. In other words, if you can show basic compliance with the Act, the court should have to dismiss. And that's not what the Court of Appeals said, and I'm not sure if you got a judge that isn't sure about how the Act applies, the lower court might get the burden of proof wrong. So that alone might be a reason that my client may pursue additional appellate relief before going back to trial court. The other option is just go back, hammer it to the judge, see if the judge does it right and dismisses it, and if not, figure out where the judge went wrong and appeal it again.
All right, well, let's talk about just for a second. There's so many things I want to ask you, and I'm pulling up the Act. And we're just starting with what do you think is a better approach for the community at large, or even for the lawyer's perspective defending someone, as to whether or not the ultimate issue of Section 4 is determined by the judge or the jury? Which would you prefer? Do you think that
Well, in answering this question, it helps to contrast what the Supreme Court said in King and Kalanick with regard to Section 8. In King and Kalanick, the Supreme Court said if you want to argue the affirmative defense to the jury, you must bring your pretrial motion. And anyone who's argued a pretrial motion under Section 8 or has watched one being argued or heard one about being argued, they're not easy. I don't see anything in the Jones opinion that says you must bring a Section 4 immunity motion if you want an early dismissal. the opinion does say if you bring a motion pre-trial, the judge has to decide it. But one of the things you mentioned in your rant, so to speak, is that there are situations where perhaps you could decide not to do that, and rather than asking for dismissal, just ask for a jury instruction on a Section 4 issue, and not even ask the judge to decide it. That if the opinion was read that way, and I'm sure a lot of prosecutors aren't going to see it that way, they're going to want to make it like King and Colonic, where you have to bring a Section 4. But I'm just not seeing that. So there are certain cases where, like Mrs. Jones's case, or Ms. Jones's case, where she's in compliance with the act, it should just be dismissed. And I think the judge should be forced in those cases. But there might be other cases where strategically you decide not to do that, and you have a good jury question. I don't think...
Like in this case, you would, without question, want a jury to decide these questions of fact because they're obvious, and the judge is just looking for reasons, trying to create new law as reasons. And if it was a question for the jury, you're saying that this would be one of those scenarios where it would potentially be for that. But I agree with you. I mean, you should probably, in most instances, not have to get there. But this does raise that issue of, these are innocuous, not even, realistic factual disputes is what you're saying. But there might be some other ones where there really are, in terms of, especially
right,
the
exactly.
And the question is going to be, now the road is going to be for as far as is that these judges are the ones that are going to determine them, like define the definitions, which is what they were suggesting is the proper protocol to go as they do in entrapment. So there's like identifiable circumstances that are outlined by rulings by the court on certain issues, such as like, how are you going to, well, I'm making a ruling that if we're weighing it, it's going to be weighed exactly like this, and I'm going to accept that as being a weight, and if it's 2.5 or less, and only under these weighing circumstances, anything else, it's not a weight that I'm going to consider, whatever that may be to make those decisions under Section 4 will then be codified for other courts to use instead of, them being open-ended and questions for the jury, I guess. But that seems troubling to me because it would then begin to develop based on, I don't know. I mean, it could be, it does go both ways. But
yeah.
But I will say this, though, in terms of the jury question, I had a personal situation, I want to hear your thoughts on this, where we had a trial and the use of the term caregiver or registered caregiver was very badly misinterpreted in the concept of the jury seeing the card, because the card says caregiver, no caregiver on it, and it's convenient. The law is not for it's not a checkers game; it's a chess game, and we can talk about it. But with the whole, do you need a card? Do you not need a card? And because we're in Section 8, but they know about the card. All of the juries know about a card of some kind. But how do you articulate to them to ignore those concepts when some of the evidence that's coming in is cards to make a point? You know what I'm saying?
Yeah, and I appreciate that, especially in a case where you might have to figure out whether you have a Section 4 immunity defense, and if you don't, then you might have to go to a Section 8. And once you're operating under the notion that you're going to try a case under Section 8, the role of the cards and the plant count, you might have a very different view of what's going to help your client in that regard. Because do you want the judge to say to the jury that, the law normally allows 12, but you had 14, so you better have a pretty good damn reason? Or do you want the judge to convey to the jury through his instructions and the way he addresses the attorneys that, 14 might be perfectly good if that's what you require under the Act? So,
for those,
every court's going to be a little different.
And just for those that are following along here, we're talking about the ruling of Cynthia Jones. Attorney Dan Groh's on the line. He's the lawyer for them. When we're discussing the Section 4 issues of what is protected, what is behavior that would normally be illegal under the Public Health Code that is excluded from arrest, prosecution, or any penalty. We know Section 4 outlines 2.5 ounces or less, 12 plants in an enclosed locked facility. You have to have a card, and the transfer can only transfer one of their 5 patients. Assuming you're doing those things, you should be protected. But what if there is a question of fact? And we're talking about this now. We know that Section 8 gives you a defense, an affirmative defense, and even though there's no defined jury instructions. And I brought into the play here that if we were to allow a Section 4 defense to a jury, which is what you're kind of suggesting, like what would prevent one from, if you don't raise it pre-trial, what would prevent one from arguing successfully that there's a Section 4 defense? But I'm bringing up the point that they can confuse one another. They can definitely interplay and I think, distract from, unless you have a judge reading a very elaborate explanation of the definition of the act and the two prongs. But would you, I guess it depends on every case. Let me ask you this. You talked about it a little before, the presumption. It has not been referenced. It wasn't referenced in this opinion. Am I correct about that?
Yeah, I don't see that the Court of Appeals made any. I made a big deal about it in my briefing and argument, but the Court of Appeals doesn't seem to add, and that's one of the major problems with the Court of Appeals opinion. On remand, it gives the lower court very little guidance. Again, I said in my briefing that the standard that they should adopt is that unless the prosecution can show that the basis for immunity is blatantly contradicted by the record, such that no jury could possibly believe it, unless the prosecution can meet that high burden, the court just has to accept the immunity. And I think that is consistent with what the Act instructs in Subpart 4D. And I think the problem in my case was the judge and the prosecutor didn't like that. And so they came up with this notion that they could explore what the true purpose was and create an issue of fact and essentially deny my client immunity on which should have been a slam-dunk case.
So you're saying that what was the standard you were asking the Court of Appeals to adopt for a trial court in evaluating the facts? You were asking for a...
Well, first I obviously emphasize what the Act itself says, that the presumption, that there is the presumption in favor of medical use. But then what I asked the court to adopt as the standard is this notion that the exact words are blatantly contradicted by the record so that no reasonable jury could believe it. That's what I pulled that from another case that was actually talking about governmental immunity. I can't see any reason why patients and caregivers shouldn't have the same protections as the police and the government. That only makes sense. So I don't think it was misplaced for me to assert that should be the standard.
Well, I had a case like that today. Something about that got into the presumption a little bit, and it has not been talked about. And I want to let me make my point here and tell me if it's come up in your arguments to the court or otherwise, and if I'm off base and seen it this way. The Section 4's outline has got Section 4A, B. It lists quantities, and then it has an exclusion of what is not counted against weight, which is the amount of seed stalks and unusable roots. And then it says a person should not be denied custody or visitation of a minor for acting in court. And then it goes immediately to that. It doesn't talk about anything else. It says there shall be a presumption that the qualifying patient or primary caregiver is engaged in the medical use of marijuana in accordance with this act if the qualifying patient or primary caregiver is in possession of a registry card and is in possession of a amount of marijuana that does not exceed the amount allowed under this act, which I think, being fair, would be no more than what their cards would allow. But it doesn't go on to say that the presumption would only exist if they have an enclosed locked facility, if they have anything about transfers. It doesn't articulate those things. And you mentioned that, general compliance, I think, in regards to Section 4. But whatever it is, like why are we evaluating Section 4 with a scrutiny of, weight and plant count and whatnot, when this presumption exists when the individual has a card and the amount of marijuana, not plants, of marijuana that they have doesn't exceed the amount that their cards may allow them? Why doesn't that seemingly just, cover all of this behavior? And then it creates this additional burden on the government to establish Not that it wasn't locked, not that it wasn't enclosed, not that you hit more than 2.5. It forces them to turn their attention to you using the card that you're standing on in an illegal way, or said another way, that your conduct, that they have actual evidence of behavior, that this card and the amount was for reasons other than to treat, seemingly forcing them to disprove it. Am I wrong? Am I crazy?
Well, I think there's a lot of appeal to that, and I think that's the way that when we initially read the Act, after it was adopted, we said that's what the Act says, because the words sure seem to say that. And I think the only shortcoming with that argument would be the final handful of words in that paragraph that says, in accordance with this Act. So that would suggest something more than the words just included in that one paragraph of subpart D. Do those extra words drag back in the notions of 2.5 ounces being the limit, or the 12 plants and locked and secured? Does that bring those issues back in? Maybe it does, but I think your point's well taken, that even if there's what I like to call a technical error with compliance with the Act, the burden should be on the prosecution to show that it had nothing to do with helping patients. And I think that's a very, very persuasive argument. I haven't seen that notion picked up in any of the published opinions yet, but I don't think it's one that we should forget about and never forget to argue about.
I was hoping that I was going to be mentioning this opinion there. Now, what's the story with? Okay, so a lot of people. I mean, let's talk about the residency for a second. I don't know if that was a factual issue or what, but the law currently, via the amendments of 2013, specifically require an individual to be a resident of the state of Michigan to have a medical marijuana card, or to get a registration with the state. What was going on with
that? Well, in my humble opinion, there was no good evidence to say that she was not a resident, and the only way that came up as to whether or not residency was a requirement in the pre-amended Act was just to say, even if she's not a resident, it doesn't even matter, that she has a residence in the state of Michigan, and that's what the Act and the regs require. But the only evidence that she was not a Michigan resident was that after she had moved to Michigan, lived in Michigan, gotten her card in Michigan, everything else in Michigan, going to school in Michigan, working in Michigan, had her kids in Michigan, she did renew her driver's license in Illinois. And again, if you have a judge that doesn't want to follow the plain import of the Act, they could say, oh, there it is. There's a question of fact. Your immunity is denied. So you don't get a dismissal. You just have to wait around or struggle with Section 8 or whatever else. So that's another reason why there's good and bad aspects to this opinion. It's just not a slam dunk.
Because she actually compelled you to have an evidentiary hearing on the issue of whether or not she was a resident or not.
Yes, we had multiple hearings in this case with all kinds of witnesses of every kind. We had landlords there. We had property managers there. We had governmental agency representatives there. We had her mom came, her mother-in-law came and testified. It was to that level, it was a travesty of what this young lady has gone through, and on remand is apparently going to have to go through it again.
What would be another scenario where a court would hold an evidentiary hearing on an issue of residency of a state? I'm just curious. Is it? I mean, I'm not able to rack my brain. I mean, one must exist. But
well, it comes up in cases often where people say live in Michigan during the summer and Florida during the winter, and they have their cars insured somewhere else, and then they have an accident in Michigan, and it comes up in no-fault litigation, personal injury litigation, insurance problems. It comes up in issues relating to child custody and those types of things. And what's really unfortunate is that the lower court really didn't look at those issues very carefully and should have certainly found that she was a resident, because the overreaching theme, or the connecting theme in residency determinations is what is the intent of the person, who is the question of the residency question. Yeah, what did they want to do? What did they believe they were? And to that extent, all the evidence pointed to the conclusion that Ms. Jones was a resident of Michigan. The only one person anywhere who was saying she wasn't was the prosecutor. And the only evidence of that was that she made the mistake of renewing her driver's license in Illinois after she had her card. But so what? That was the only connection she had with Illinois in this case.
So what, she's got a Section 8 defense as well, is that right? I mean, that's always your anchor.
Well, of course, but that's, the way that's being interpreted in many courts is, they're not observing Keel. They're not giving the cards any credit, so you have to bring in your patients. You have to bring in their doctors. You have to bring in your own doctor. You have to air your private medical condition. And these are all things the Act promised not to do. The Act promised people that your medical condition was going to be private, that your cardholder status was going to be private. So to make someone go through the hoops and jumps of a Section 8 is not only to waive your own medical privacy, but the medical privacy of your patient, at least on some level, even if you follow Keel, which the courts I practice in are not following Keel. So
are they not following Keel? Are they not following Keel when Keel's used to present the card to represent the defendant patient or the defendant patient in that instance, or for the caregiver defendant who wants to bring in their patient to attest to a quantity of the reasonable issue? Are they requiring it for that scenario?
In the courts that I practice in, they routinely are not recognizing Keel at all. So it's just as if the cards do not exist. You need to bring in the doctors. You need to bring in the patients. That's what I'm getting over here in West Michigan.
We agree, and we haven't talked about it, but I believe we have a meeting in mind. We may have talked about it, but the quality of the this is not an opinion that Michael Komorn has, and I don't think it's your opinion either, because I know we've talked about what this doctor's intentions were as a Greek gatekeeper, but the scrutiny that you're speaking of, to which the courts, judges that you're in front of on this particular case, they're looking for ways in which they can deny a defendant some right that they want to assert under the Michigan medical marijuana. They are going to find it. And the weakest link in all of this has been the medical marijuana certifications. And it's been a problem. I've talked about John Chargowski. We were making jokes like, how many times a client calls you and they say you say, who is your doctor? And they say, I went down to the the expo, or I went to the circus and I rode the elephant and I went in the tent and I smoked some weed and doctor certified me, and what's his name? You know him. He's you hear a lot of that stuff, and it's just not the way it's supposed to be. Now, that is not the patient community's fault. They've come to accept this, but that vision, what they see as being the way, is not making the case. And in jurisdictions like yours and the one that I practice in, the scrutiny is strong, and they know coming in that they will have the upper hand on that issue. Would you agree with that?
I didn't agree with that entirely. And the narrative that you hear from the doctors that would like to help their patients is something like this. When the Michigan Medical Marijuana Act passed, we basically were instructed that if we recommend medical marijuana for anyone at this clinic, hospital, facility, you're not going to be with this clinic, hospital, facility anymore. So you had well-intentioned doctors that would be very happy to give a medical marijuana recommendation, but they felt their hands were tied. And that opened a secondary market for doctors that either had disciplinary problems or had lost their medical privileges elsewhere or whatever else. And there's a lot of great doctors. I work every day with a lot of great doctors that stand behind their patients 100%, that come to court. All I have to do is let them know with some decent heads up, and they come to court, and they testify, and they do a great job. But in a lot of communities, they don't have that kind of support. And so then you kind of got this B team of doctors who came in on kind of unusual circumstances. And these guys, if you go to subpoena them, you're lucky if you can even find where they are. Unfortunately, under the new statute, that's going to get better. But there will be a window here where
it's only going to get better if people are aware of the trap that has been built. So what we're saying, listen,
Yes.
it's not just me screaming this every week. Dan Groh, the other side, said that we did not plan this, talk this out, we haven't fell into this issue. But what people have come to understand as being an acceptable certification is they take the records, and I'm talking about an individual that 10 out of 10 doctors would identify the condition as being one that met the qualifications of a debilitating condition. I'm saying that that's not, but they would go to a doctor, they'd see the doctor, they'd participate a little bit, they'd look at some records, nothing special, and they'd come back after a year with no interactions in between. Well, now the law says you can come back after 2 years. And let me tell you something, coming back after 1 year, that wasn't going to fly. And it's not going to fly. So now 2 years is a trap. People think they've been given a benefit of only needed to pay one fee every 2 years. Well, guess what? You go to your doctor to get your card, and if you think that paying $50 is going to make your defense in court, and you expect it, you're going to lose. Dan.
Agreed, 100%. And actually, I tell people very frequently that if you're going to go to a doctor that only recommends medical marijuana, and that's what they're there for, is just to fill that gap, go to your family doctor and tell your family doctor all about it. And go to your family doctor frequently and tell your family doctor how much it's helping you and how you're not taking all the Vicodin that you used to need, or you're not taking all the whatever it was you used to take that was half killing you, because it's been replaced by medical marijuana. You don't have to ask your family doctor to do that certification form, but get the doctor involved. And then if you ever do get in trouble, you track down the recommending doctor, and then it's bootstrapped by your family doctor. And the family doctor doesn't have to explain how medical marijuana works or how the CBD does one thing and the THC does another thing. Maybe your recommending doctor can do that, but your family doctor can give legitimacy to the whole thing. And that can create a really strong defense. So it can be done, but not everyone goes through those steps. Not everyone understands what a trap getting where your only contact with the doctor is every 2 years you get your cert renewed. So that's a really important point that I think everyone should know.
And it should be emphasized with what we're talking about here, your case, that these protections are being, like a court, like who would ever think like there's no issue of residency, there's no issue of, what was the other issue? The other issue was
the so-called true purpose of why she had that marijuana in her trunk. It doesn't matter. She was within her limits, should be dismissed unless the prosecution can come up with a really damn good reason why it shouldn't be dismissed. And they didn't. They just said, there's this question of fact. Maybe there's some other true purpose. So it's a witch hunt. And hopefully on remand we won't have that problem. We'll see. Or on appeal.
Was it dated the alleged culpable act before the transport law? I mean, was she acting?
Well before. It's 2011.
Okay. Right, I was going to say. And it would seem like that seems to be even more of a safe, like it's almost like you would tell people to do that as good legal advice, right? Back in the day.
Right.
Don't.
And in fact, it was locked in her trunk in this case, so that's not even an issue in this case.
Right. They did, as mentioned, I did see that they were not using the. What was the other issue that? The amendment now that requires the state residency. There is a footnote about how they're not using it retroactively. Have you had any other cases where you're having judges apply the standards of the amendments to be, culpable dates that preceded them?
Well, the way that it's come up in my cases most frequently is with regard to the bona fide doctor-patient relationship. And now we have some additional factors that are in the statute that the judges I've been in front of, well, they're not saying that it's necessarily controlling. They're certainly finding it very informative, and at Section 8 hearings, they have been indicating that they want to hear about the types of things that would be relevant under the new statute. And I think rather than creating additional hoops and burdens, they're thinking that, well, let's just put a little flesh on these bones and kind of, the word was in there before, but it didn't have a definition. Now we kind of have a definition, so let's work with that. So that's where I've seen it most frequently.
People often ask, and I was kind of trying to flesh this out a little, and I have a case right now where there was an issue of outdoor grow, and we argued about the police officer's complaint of its non-compliance was that it didn't have a roof, and I said, show me the law where it says you can't have a roof, and they couldn't do that. And the judge was interested, but nevertheless, when the judge bound my clients over, made a finding that it wasn't locked and enclosed, and used the 2013 marijuana grown outdoors should, that language, and I filed this motion to argue that it's ex post facto. There's no notice of it. How could someone have any idea? Of course, there's all kinds of traditional constitutional arguments, but yeah, I guess the only way out would be for them to say, well, I used that language because to me, when I looked at it, on the date of the culpable date, that's what it meant to me. And the legislature just kind of put it together and just, I use those words because I've been using them advisory, but that's how I always envisioned it. That's
exactly
what you're saying. Right?
I looked it up in the dictionary, and lo and behold, it said the same thing. So yeah, I'm not relying on the statute. It's just consistent with the way I'd already been thinking about it. Yeah, they could easily dodge it in that regard.
Well, people often ask, and I think that this what we're talking about, legislatively amended laws, its application to behavior that preceded it, not on procedural things, but substantive notice of ways in which people are going to be judged, especially for immunity or not. But in terms of court cases, people often ask, what's the application of, let's say somebody was arrested and convicted or pled guilty in a case where they, dispensary, and then, let's have a good example. Let's see, or that something may have happened, or let's say they were told they couldn't have a Section 8 defense, after McQueen, or when McQueen was on appeal or what have you, and
right.
Or the application of a case. What's your version of when a case has been issued by the Court of Appeals? Its application on pre-culpable behavior.
Well, one of the things we could look at is driving under the influence of drugs and the way that's flip-flopped. There was my most recent case is one that I kept in court long enough such that the Kuhn decision benefited him, and ultimately he had his case dismissed. I handled other cases, almost a year ago where we pled them guilty. And I think where that's probably going to come up the most strongly is when one of those folks who pled guilty under the mistaken construction of the DUID statute is then accused of having a second conviction. Then the question, I think, will be, can you go back and undo the first one because the plea was taken under a misconstrued version of the law? And that's something that I'll defer to some of the super smart appellate lawyers that you and I work with on a daily basis.
I want your answer. I was asking John. I want your answer. I was asking John Targowski the same thing. The issue comes up. It's a due process claim. Arguably, the general rule is that the courts look to some kind of indication in a ruling like that gives it strength to be retroactive.
In the DUID situation, I would suggest that if you pled guilty under the old Kuhn, you should be able to withdraw, get it, 6500 motion and not have it. That's not a proper venue in district court, is it? You got to find some other. Yeah. Which is like where some of those. Right. So I think that's what ultimately should somehow be able to be done, and how to get to that conclusion is an altogether different story. But
all right, listen, the phone lines are going crazy. I know we got one special guest who is the significant other of your client, Sale Ali. Is that you, Sale? We got you on the line here?
Yes, yeah.
You're on Planet Green Trees with superstar lawyer Dan Groh. Michael Komorn, I'm an attorney as well. And we've got some
Sal, how are you doing?
So,
hey, I'm doing good. How are you, Dan?
So what do you think, other than we all agree that Dan Groh's a great lawyer for fighting this case and his whole grasp of the issue, where are you guys at? You still inspired, or is it beating you down?
It's really beating us down. I mean, I mean, this is 5 ounces of marijuana. I mean, in this case we've been fighting for almost 3 years now. You know, I go to court with her in Berrien County. I mean, it just seems like the prosecutor there has such a hard on for medical marijuana that, I mean, I'm in court sometimes where I see people getting charged with, you know, all types of different stuff. Oh, slap on the wrist, probation, you know what I mean, let them go. Like, we're fighting this case for years now, over 5 ounces, you know. And she was completely within the law at the time, so I don't know.
It's ridiculous, I know. I mean, you know,
Very frustrating.
There's a lot of politics in this. You don't really get there's always politics in the law, but it's more exposed because of the fact that there's no case law. Like, if you got a judge, I mean, Dan will tell you there's been many, many times when he's had what he would believe and argue is the law on his side and the facts on his side, and he's just maybe in front of a judge that is not going to pull the trigger and let a defendant go. They're just not going. The former prosecutor or maybe a former defense attorney thinks they're all liars. I don't know. But whatever it is, you know, there's politics with that. But when they do that, they can render their opinion, and they've got a lot of discretion. There's a lot of cases that support them one way or the other because the issues have been litigated so many times. Here, there's very little, if any. Like the issues Dan's dealing with, your cases, I mean, I describe it as like you're on Mars, and Dan's got to pick up a rock, and they picked up a rock, and you guys are going to figure out if the rock's going to, you know, there's like all new territory. You're just wandering out there in areas, and I don't know. That's the challenge, but you know, it's you're being guided, you know, by good lawyers. Got obviously great.
No, yeah. I mean, Dan is awesome. I mean, he's been, you know, there for us from the beginning. I mean, he's been there for me even prior to that. I mean, I've had some really messed up issues with medical marijuana since this thing, you know, since this law passed. Just with everything being so unclear and so gray, you know. And we're just trying to do our best to work within the law, and it just seems like you can't win for lose, you know. And
it is frustrating. It is frustrating. A lot of people. Go ahead.
What he's saying is the truth. We've been fighting we went through a long, hard battle. We got into some things involving townships and municipalities and the way police and law enforcement was going to handle searches, and we fought for a long time, and it was one of the most frustrating and least rewarding activities that he and I have probably ever been involved with. And it really shows the bias that exists, that law enforcement can do no wrong, and everything that caregivers and patients do is wrong, and it's just a matter of catching them. And that's kind of what we see in the courts.
It really is unfortunate. I mean, and it's all a waste. I mean, when you really think about it, it's just almost like intellectually dishonest to, you know, listen to it and think that it's, you know, like I could just like let it go on and not say something, or just let it, you know, just 5 ounces. How many court appearances? How many hours of taxpayer dollars, you know, billed and paid to officers overtime or transporting evidence from one place to the other? I mean, it goes on and on and on. It makes no sense. Let me see if we can get a couple callers on the line. I mean, we got a 313 call. This may be.
Yeah. Hey. Hi. Michael.
Okay. Yes.
Yeah. Hey. Tim Beck calling. Dan, Michael, and the other gentleman. Just an observation, and please disabuse me. I think that Berrien County, from what I understand, is the most extreme. You know, this prosecutor, Art Cotter. It is right. This guy, as the gentleman said, has a hard-on. I mean, he really. This is just, and I think his tentacles, stretch all throughout the county, more or less. And I've been pondering, this decision as to whether it's a good thing or a bad thing for the judge to have deciding power. On another level, I think I kind of maybe have to agree that in most instances it's probably cleaner, okay, if the judge decides. especially if it's an honest judge that follows the law, reads the plain language and everything else. But in certain counties, you're going to get screwed. I mean, I don't know. It's a quandary, but I think this Berrien County, it's really extreme. And I heard, methamphetamine in those counties, it's a serious problem. I don't know. I mean, you up against, I don't know. I'm just ranting here.
Well, the thing is, Tim, and I think you've picked up on some good points, that in some jurisdictions you might know that you have a judge that's just not going to grant a Section 4 immunity motion given the facts that you have. And like Mike has picked up on, maybe in those cases you don't telegraph that that's what you're going to do early on. You get it up to jury trial, you get the proper jury instruction, and you kind of hide the football a little bit. Maybe that's possible under this opinion. Unlike King and Kalanick, where it said expressly you must bring it in a pretrial motion, the way this opinion was written, it's not in there. It doesn't say you must bring it. It certainly says if you bring it, the judge has to decide it. But and clarifying that issue and the burden of proof might alone be worthy of taking it up to the Supreme Court.
Mm-hmm. Well, what's also scary about this decision, to me, at least as a caregiver, is that one of their reasons for rebutting her defense is saying that she had drug records. This was literally names of strains and the amount of the strain. Like, we can't even catalog a strain and put the amount of a strain. Like, how are we supposed to know? And that becomes drug records. You know what I mean? Like, that doesn't even make any sense. Like, as a caregiver, how?
And I have to add to that, the way that went down at the hearing was really, really sad. They brought in their senior drug cop to testify as an expert as to drug logs and all this stuff. And they said, well, it could be consistent with drug logs. And they said, yeah, it could be consistent with the medical use of marijuana too, right? And it's just, well, I don't know anything about it. It was really too bad the way go ahead.
Well, I know. I'm just asking a question. I'm not an expert here. This has been It's been a great show. I mean, the quid pro quo, the going back and forth has been like really fascinating. And again, there's different facets here. I'm just thinking again, this Berrien County. I mean, this is really extreme. I mean, this Cotter. I personally suspect it's pure politics. And politics sometimes permeates its way into the law, as sausage is made in certain counties or something like that. But again, I've had mixed feelings, about this whole thing, and probably, I guess I would defer. Maybe it's worth an appeal, to the state Supreme Court. It almost sounds like there's nothing to lose. Am I wrong?
Well, here you go. Instinctually, I find it to be not a great opinion because of the fact that just the judges that I practice in front of, and I guess I have a way to kind of pose what the answer might be, but the judges I practice in front of, they too like the ones that dance.
They won't ever grant one.
Yeah, and I know going to a Section 8 hearing, the best I'm going to do is I'm going to get to a jury, and I have and there's a possibility that I may not, or they'll deny the right to get to a jury. So in my mind, behind all of this, it's the voters' initiative, it's the people's law, and to me, the people that voted for it are going to be on the jury. So overall, if I took all, the next 10 judges I'm going to appear in front of, arguably, and had to, pick between, those 10 and a jury 10 times on the issues that come up on some of these things, and having some control over the jury instructions, because it's confusing. I've been through it once now. But I would think most times I'd want a jury. Just I think overall, politically, more people that will end up on juries are going to find this ridiculous and that they got to sit there because someone's door's not locked, or fighting about that stupid stuff, versus 10 judges that would find some crazy law, some way to create some, adverse, standard of proof or whatever. Dan, what do you think about that as a way to evaluate it?
Well, and that's the major shortcoming of the Court of Appeals decision the way it's written now. It doesn't give the lower court a lot of guidance on what is the burden of proof, who has the burden of going forward with the evidence. Is it, what is the standard? And if the court had adopted a standard like I suggested, that basically, unless it's flippin' ridiculous, you have to dismiss the case, then cases like this wouldn't even make it through the gate. She probably wouldn't have even been charged. They'd say there's no way we can show this under the Jones standard, so we're not going to even charge the lady. And that would be the best outcome. You don't have to go to court at all. The second best would be, you have to decide it, and you have to use this really tough standard. And then people like Cynthia Jones would have her case dismissed. But allowing the judge to come up with excuses to not dismiss, that's where the problem comes in.
If I'm correct, you had some kind of hearing regarding Section 4, and the judge ruled adversely, but allowed you to, or ruled in some capacity that you could take it to a jury. Is that right?
We were prepared to go to trial, and the prosecutor filed the appeal. We did not appeal. We were prepared to go to trial, and we thought we could win. But the prosecutor
arguing factually about Section 4, right? Yeah.
Yep, that's exactly right. Because it was unequivocal in my mind. She was a Michigan resident, and she was in compliance with the numerical limitations of the Act. What else does the jury need to hear? It should be just, we win.
And you argued before the Court of Appeals that they should adopt the finder of fact for the Section 4 determination should be the jury. You argued that similarly at the Court of Appeals?
Well, I argued that the judge, and it's complicated because I didn't want to necessarily argue that because that would deny, in a vast majority of simple cases, going to jury trial does not mean immunity from prosecution.
You're right.
If the standard was proper, then the Joneses of the world wouldn't have this problem. With the incorrect standard, then you have the problem. But the vast majority of the clients that I represent would like to know that before the prelim even, before anything, you just go to court, you show your cards, prove the amount, case dismissed. I think a lot of people would like to be able to do that, but if the judge can create, witch hunts into what the true purpose of the possession of the marijuana was, then you got a problem. So like I said, my first comment was this case is real simple. Should have been dismissed. Then we wouldn't have any of these issues.
The worst part of all of this is whatever we would say now or however we would feel right now, we may feel different later. Like the whole, if there's an evolution at all, courts may come around, and you're right, it may be a much easier remedy to get in and get out instead of, But so it's an interesting issue, and I appreciate. I think I've asked you 9 different ways, what position you've taken. You've gone, well, it depends. It really does depend, and maybe we don't need to commit to it right now. But fascinating stuff. I know we've got Barb Agro on the phone. We want to hear from her, and I didn't want to keep you guys, although I could talk to you all night about this. It's fascinating stuff. We're going to have you back on the show. Any final thoughts or anything? Any other comments for advice for people as we go to a break and come back for Barb?
No, it's just too bad that our judiciary, like our medical community, has not embraced medical marijuana like they should have. I think that's what the voters are trying to say when they adopted the act, and I think the court's reaction and the medical community's reaction has not been what the voters wanted.
Agreed. It's unfortunate. All right, so Sal, listen, stay strong, and the one thing you always have on your side is it's hard to beat the truth and it's hard to beat science. So you got all that. You got the anchor of all of that on the other side if you need it. But I wish you guys the best. We're going to have to hear back from you when you get back there for the remand.
We truly appreciate it. Thank you, Dan, as well.
Good hearing from you. Thank you, Dan. Right on. Really good points. Michael, you too. Really good. Great show as usual.
We love you, Godfather.
All I would like to say is I just want to say to the listeners that, these cases, people should, really listen to these cases and take this information in because it can affect everybody. A lot of people are just so oblivious. They think they got a card and everything is just fine, but it doesn't work like that. So.
All right, very good. Okay, so thank you, gentlemen, and everyone be safe, and we will look forward to talking to all of you real soon. Thank you very much. All right.
Thank you.
This is Dan Groh, Sal Ali. Dan Groh, of course, the lawyer on the Jones case we just spoke about. Sally, the significant other, and, of course, the godfather of marijuana in Michigan, Tim Beck. We're going to go to a quick break. We've got Barb Agger on the line. Barb, I see you. Stand by. We want to come back and maybe take a few more callers. And we're going to be right back. You listen to Planet Green Trees. The call numbers are 1-347-326-96